I am going to go ahead and get started since I am running a little bit late. We had some technical difficulties, but I will let people in as they come in. The third Thursday of every month, we'll be doing a live Q&A webinar via Zoom to cover some of the workplace issues that a lot of people are dealing with. What we're going to cover in this particular webinar is informal resolution and mediation of workplace disputes because it is Global Diversity Awareness Month as well as Mediation Week. As a matter of fact, I believe the ABA is now calling this Alternative Dispute Resolution Day. So welcome to ADR Day. Especially with the types of topics we talk about, we want to make sure that we're remembering we're here to learn and grow, not necessarily to do what a lot of people do on the internet these days, which is blame and shame each other. That's not what we're here to do. I just ask that you keep things respectful and also honor the privacy of the other people in the room. I will do that. If there's any question that comes up, something you want to discuss, before I would ever use it on social media or anything else, I would let you know. We are not live on LinkedIn currently, so that will be another thing that will open up a little bit more opportunity for you to speak freely. The third agreement is to listen deeply. That's when we use our third ear. If you look in the English word heart, it's right there in the center. So what I'm asking you to do is just listen with compassion. That means listen for the hurts that are being expressed, listen beyond what the words are, because a lot of people sometimes when they're struggling with something emotional can't always express it in the way that we think they should. We want to look for what is it that they're trying to relay, what's the problem that we need to solve, and is there something that we can solve? That's what mediation is all about. It's a very different process than how we litigate cases in a courtroom. That's one of the reasons I frequently will say, court sucks, and it's my goal to keep you out. Again, this is Global Diversity Awareness Month. We're celebrating differences among all the different types of people in workplaces. And when we're talking about diversity, I think a lot of people either think gender diversity or racial diversity, maybe ethnic diversity, but we're also embracing the various types of diversity, such as religion, physical and mental ability, economic status, educational status, right? We have a lot of different types of people coming together. Depending on how big your workplace is, you're going to continue to see that diversity. And it will bring maybe some additional challenges, but I'm guessing that very few people have worked in a workplace where everything goes perfectly every day. What Diversity Awareness Month is for me is about discussing the ways that we resolve those personality conflicts. Instead of giving up on each other, let's look for new ways to find common ground and work together, because no matter where you go, you're going to find somebody who is different from you. And even if they seem a lot alike in the beginning, there's a very good chance that the longer you work together and the different types of projects that you work on together, you're going to find differences of opinion. So what do you do in those situations? I hope to give you some tools today to do exactly that. Mediation is one of my favorite alternative dispute resolution processes because it's also cost effective. When we're talking about cost, we're not just talking about money, we're talking about time, money, and energy. I have been a plaintiff in an employment lawsuit, but that did not mean, first of all, that I collected on the judgment that was awarded to me. That's a whole different story. It also cost me a lot of time, money, and energy. Even though I had an attorney who was being paid on contingency, I still had a lot of out-of-pocket costs because I had moved out of state from my prior employer and had to commute back to the courthouse only for the opposing party to not show up for mediation, for the actual trial. I like to tell clients, I'm not discouraging you from litigating. There are definitely cases that you need to litigate because you're not going to find a willing party on the other side. They're going to keep digging their heels in, and you have to keep pushing forward before you can get any leverage to reach a settlement. I understand that, but if you can avoid it, we definitely would like you to. Here's the experience I had. It took my case 4 years to get to trial. Every time I started to move forward and feel better about my life, it would be some sort of discovery demand, a motion, mandatory mediation. Mediation is supposed to be voluntary. These things that kept bringing me back into the past. Although I was in law school where I was learning the court process, both in the courtroom and in the classroom simultaneously, it kept pulling me back into a very bad experience at a prior employer. That's what I mean by the energy cost. You keep getting pulled back energetically, and that's on top of the time and money costs. Then, of course, you typically will lose relationships in an employment setting. When you leave your employer and then sue them, there's a very good chance you're not going to have people write you recommendation letters anymore. Then the fact that it's public record is another consideration. There are definitely costs to litigation that people don't always think about. So what are those alternatives to court? There's arbitration, which is going to look a lot like a court hearing. It's just going to occur a little more quickly and in a private setting. Mediation is where someone like me, a third party neutral, is not going to tell you whether you're right or wrong, not going to make a binding decision, but will help you form an enforceable contract. It's, in my opinion, a much more empowering process because both of you get a say in how it goes. In mediation, you get to choose what you both can live with for the future. Arbitration sometimes is very past focused. Of course, there's negotiation. Sometimes you might just be able, with a little bit of coaching or some guidance from an attorney, to directly talk to the other side. Sometimes we can work it out in negotiation, but we don't always know how to approach it. We don't always know how to say something. And that's where I get involved with a lot of parties too. I find that very empowering when you can take on your own negotiation. To go a little bit more deeply into what arbitration is, both sides, just like in court, will have an opportunity to present their arguments and their evidence to the arbitrator. I do some arbitration, but again, I prefer mediation because I want the parties to weigh in. You can see in arbitration, it's me, the arbitrator, or usually a panel of arbitrators who are weighing the information on both sides and then evaluating it, judging you as the party, judging your evidence, and then deciding who deserves what. It's a more empowering process to do mediation. There sometimes are opening statements that look a lot like court, but usually we'll lay some ground rules for the session that, similar to the ground rules that I have for this particular webinar, that will say, for example, we're here to solve a problem. We're going to solve it together. You're going to get a chance to share your perspective, to share how the conflict has impacted you, but we're going to be very problem-solving focused. We're looking for this to end in a way you can both live with. Then you'll draft an agreement, sign that off, and hopefully move on with your lives complete and happy and time, money, and energy where you want it. Other informal resolution methods that we sometimes use in workplace disputes are ombuds intervention. We see that in huge corporations, sometimes in higher education, where kind of like your HR person serves in that role, and they try to be neutral. You can have some outside ombuds as well. I have been in that role before, just like neutral evaluation, where will have a non-binding opinion. Sometimes parties will come to me and say, what do you think about this? Usually I'm only working with one side, similar to legal counsel, and saying, this is a case that you can go back and propose a solution. Here's what I would recommend. Or it might be where I've counseled people how to gather their evidence and consider whether they might have a legal claim. They work with the other party in that workplace. And it becomes pretty apparent when one side is playing by all the rules. For example, in a performance improvement plan situation, a lot of times people feel like maybe they're being singled out because of their membership in a protected class. So the first thing we do is look at that performance improvement plan, or PIP, and we say, here are the rules that they've given you. This is how you win the game. Let's look at that in the context of the other rules that you have in your workplace, and let's line up your behavior. If you still aren't making progress toward a resolution, then it starts to look a lot more like there may be something discriminatory going on. I will often advise that party to seek legal counsel. Although I am legal counsel, I no longer litigate because I'm fully focused on keeping people out of court. In the context of diversity, equity, and inclusion, we've seen programs being eliminated, we've seen them scaled back, and we've seen them reformatted. What do you do about protected classes that come into conflict? If you have questions around that, or if you just have questions about the process, feel free to ask. I'm just going to make sure that I did not fail to let someone into the room. But in the meantime, there is my contact information. I taught a class earlier this year on the fact that there is no hierarchy of protected classes. I have gotten a record number of requests to consult on that particular issue. We've seen it in a lot of workplaces since October of last year, where there are people of color who are very strongly aligned with Palestine. And then you have people who identify as Jewish who are very strongly aligned with Israel. They're in the same workplaces, and although we have freedom of speech, maybe not in the workplace. We've seen some of that come up. We've seen disciplinary action in both directions. Are some more marginalized than others? Should we be ranking them differently? The short answer to that is there is no hierarchy. All protected classes have equal protection. There is a case currently pending before the Supreme Court of the United States that will be decided this term. They are actually addressing whether there should be a higher burden of proof for what we would consider less marginalized communities. The plaintiff in the Ames case is a straight white female, and she claims that she was denied a promotion because a gay man was given priority over her. I'll be following that case and giving more information about it. I always close my videos with, keep listening with your third ear. For those hurts you can heal. Because again, that's what most of this is. It's people coming into conflict because we have a lot of trauma that we pull forward. I help people all the time work through them so that they can put their best foot forward and advance in the careers that they want. Thank you for coming. I apologize again for the technology issues, and I will get that worked out before next month's webinar.